Good morning. Welcome. Thank you all for being here bright and early on a post-Halloween morning, and I hope everybody had their fill of candy. I'm happy to be joined here this morning by my Chief Deputy Ron Flynn and Deputy City Attorney Jeremy Goldman. Both have been working diligently on the case which we are going to discuss this morning and that we filed documents on this morning. As many of you know, a national civil rights group, Equal Justice Under the Law, filed a federal class action lawsuit against San Francisco last year, alleging that the state-based money bail system is unconstitutional. Their argument was this: the state's money-based bail system unfairly allows the wealthy to go free while the poor and working class are forced to remain in jail. The lawsuit was first filed against the state and the city. Sheriff Vicki Hennessy, who oversees the city and county of San Francisco's jails, was later added as a defendant, and the court dismissed the claims against the state and the city. My office represents the sheriff as legal counsel. Up until now, my office had not taken a position on the merits in this case. Since this action was filed, we have worked diligently to clarify both the plaintiff's legal arguments and what they were seeking before we took a position on the validity of the state bail law. We also worked hard to protect San Francisco taxpayers from any monetary damages that might result from enforcing a state law. We've successfully done those things now. Now it's time to get to the heart of the issue. Is the state's bail system unconstitutional? In the current bail system, people arrested on suspicion of a crime are held in jail until they appear before a magistrate, unless they can pay a set amount of money as collateral. Those amounts are determined by what's called a bail schedule, and state law requires that Superior Court judges in each county establish one, and that sheriffs enforce it. If you can pay the amount on the schedule, you get out of jail. If you can't, you don't. That approach doesn't take into account risk to the community, just whether you can pay for your freedom or not. That creates a two-tiered system, one for those with money and another for those without. It doesn't make anybody safer, it's not right, and it's not in keeping with the Constitution. It's time for it to stop. To echo U.S. Attorney General Loretta Lynch, we need to ensure that in the United States there is indeed no price tag on justice. I believe the state's current bail system, specifically the bail schedule process that happens before arraignment, is unconstitutional. That's why today my office filed papers in federal court indicating that we will not defend that law. I want to take note that we're not taking legal issue with the existing bail process prior to the point of arraignment. At arraignment, a judge or judicial officer has the opportunity to review the circumstances and make an individualized bail determination based on all the factors. A bail schedule that lists the price of freedom without any consideration of the individual circumstances does not serve the interests of the government or the public, and it unfairly discriminates against the poor. Government entities in other states have started taking steps to tackle this problem. In other lawsuits, smaller cities in Alabama, Kansas, Missouri, Mississippi, and Louisiana have reformed their municipal bail practices. With my action today, however, this appears to be the first time that a government entity has refused to defend a state bail system in court. To be clear, dangerous people who pose a risk to the community need to remain incarcerated. But how much money someone has isn't a measure of whether they pose a threat. Right now, we have a system where someone who does not endanger the community can be locked up for days because they can't pay for their freedom, while someone who could be very dangerous is free because they could pay the bail amount. A poor person who possessed marijuana for sale could be locked up, unable to pay $10,000 in bail, while someone able to pay $150,000 could be out of bail for rape. That needs to change, and that's why we're taking this step. This has been decades in the making. When Robert F. Kennedy was the U.S. Attorney General in 1964, he said, usually only one factor determines whether a defendant stays in jail before he comes to trial. That factor is not guilt or innocence. It is not the nature of the crime. It is not the character of the defendant. That factor is money. In testifying to Congress, Attorney General Kennedy told the story of a man who spent 54 days in jail because he cannot afford the $300 bail amount for a traffic offense for which the maximum penalty was only 5 days in jail. 2 years later, Congress passed the Bail Reform Act of 1966, which abolished the use of bail conditions that discriminate against indigent arrestees in the federal system. The federal system uses a risk-based model detaining only those people who are either a flight risk or a danger to others. There can be conditions on release like providing a DNA sample, restrictions on travel, or a curfew, but bail cannot be set in an amount a person can't afford. As the U.S. Supreme Court noted in a 1987 ruling, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. States, however, have not necessarily followed suit. As an example, a report this year by the nonprofit, nonpartisan Prison Policy Initiative found that there are 646,000 people locked up in more than 3,000 local jails throughout the United States. 70% of these people in local jails are being held pre-trial, meaning they have not yet been convicted of a crime and are legally presumed innocent. In February 2015, the U.S. Department of Justice filed a statement of interest arguing that bail practices that incarcerate indigent people before trial solely because of their inability to pay for their release are unconstitutional and violate the 14th Amendment, which guarantees due process and equal protection under the law. In March, the U.S. Department of Justice issued an advisory to state and local courts that said they must not employ bail or bond practices that cause indigent defendants to remain incarcerated solely because they cannot afford to pay for their release. Keeping people locked up for no reason other than they can't afford to post bail has other consequences. People lose their jobs and their homes. Families fall apart. Taxpayers shoulder the cost of jailing people who don't need to be there. In other words, the current bail system is not just unconstitutional, it's bad public policy. And I would just like to point out two things. The District of Columbia has been very proactive in this area, and they don't use pre-arraignment bail, and has worked very well in the District of Columbia. In fiscal 2015, more than 91% of District of Columbia arrestees were released. 98% of them avoided new arrests for violent crime during their pretrial release. 88% of them made all their scheduled pretrial court appearances. This is an issue that has garnered national attention, and most recently you will note that the Chief Justice of the California Supreme Court just last week convened a working group that she has charged with coming up with recommendations by December 2017 to deal with this situation, which everybody knows needs to be reformed. And we are hopeful that with our action today, we'll give impetus to that effort and ensure that we have a reformation of a bail system that is no doubt here in California unconstitutional. You may also note that Assemblyman Rob Bonta has called for the need to reform the California bail system and the laws governing it. And we plan on working with Assemblyman Bond to make sure that today's action has impetus and that we see reform at the state level so we have a bail system utilized here in California that is constitutional, that is fair, that is workable, and that protects the public that it is intended to protect. So I thank you all for coming, and I look forward to taking any questions that anybody has. Thanks very much. Questions? Bob.
Who's left to defend the system?
There will be two options. Number one, the state attorney general can step in and defend the constitutionality of the state law. Or number two, there has already been earlier in this case a motion to intervene by a bail bondsman group. That motion to intervene was denied. I would anticipate that they will renew that motion. So it would either be the Attorney General or an intervener to defend the law, and Judge Gonzalez-Rogers will make that determination. And I think it's likely that there will be someone to step up to defend the constitutionality of the law. But from our perspective, it's not something we're willing to defend because of our belief that it is unconstitutional.
So it could be construed as a bombshell for those people who have families who've gone through the system. So when people see this story tonight, what is the takeaway for those people? And will this mean your announcement today that
No, I don't think it's likely that there won't be changes tomorrow or today. As Bob just alluded to, this case is proceeding in the federal court. It is likely that someone else will make an effort to defend the law, and we'll have to wait and see how that litigation plays out. But this is a pretty big statement. It's the first time a city has stepped up and done this, and I think that it sends a message loud and clear that there will be changes in the future. And I think that at the legislature, the courts, this is going to be a message that people have to prepare for the potentiality or eventuality that there is going to be a change in the system that we have. But I do not anticipate we won't see anything in the next several days.
More of a call to action.
Well, it's not necessarily only a call to action. It's a concrete step which gives further impetus to a movement that is growing across the country. There are others, advocacy groups, that have calls to action. My job is to defend laws, and when I think one is unconstitutional, it's not something I'm necessarily going to step out and defend, and this is what we're doing today.
Why not settle it then? Rather than not defending it, you believe it's unconstitutional.
No.
Settle what the plan is, reform the bail system, say you guys are right, and let's
Well, the reformation of the bail system has to start in the state legislature. That's not something I have power over. So, like I said, Assemblyman Bonta has already stepped out and said he's going to be an advocate on bail reform. So we'll wait and see what happens at the legislature. So no, the state mandates that each court system in each county have a bail schedule. So that's something that has to have at the state level. Yeah.
Can you just put that in perspective? How long has this system been in place? I mean, what are you up against?
Well, it's been in it's been it's been decades. This is the current system. It's been around for decades, and it is the entrenched system. As I alluded to nationally, Robert Kennedy was talking about this back in 1964. So this has been the norm in the United States, and it's certainly the norm here in California. So this is a very, very big step.
So what would you propose happen then? I mean, I know you don't have like a crystal ball or you don't have the exact, what you would, I guess, envision happening, but I'm just curious as to the people who do have the money, would they still be required to pay? Because isn't that considered unequal as well?
Well, if you look at it, what needs to happen is everybody needs to be treated fairly and equally under the law. And with the current pre-arraignment bail system, a person who has the means just pays the money and they walk out. The fact of the matter is that everybody should be treated equally. In post-arraignment bail, everybody has their case individually reviewed by a judge who makes a determination about whether they're a flight risk, what is the risk to society of that individual being out on the street. Here in pre-arraignment bail, you don't have that. So what we need to have is an even-handed, fair enforcement of justice and make sure that all cases are individually reviewed by a judge who makes sure that that person does not pose a flight risk or minimize the threat to the community. And then that there are a variety of other ways in which you can assure that that individual is going to make their court appearances and show up for trial. You can have all sorts of supervision, from check-ins with the court to emails to supervised visits to making sure that individual is being supervised and that they are going to return. It shouldn't be based simply on money. And everybody has to have their case adjudicated in a fair and even-handed way under the supervision of a court officer.
What I'm saying is the people who do have the money, are they going to be,
Well, their case.
have the same standard, or will the people who still have the money still have to pay?
Well, we'll have to see. Every case is adjudicated, should be adjudicated by a judge. Certainly, bail might be a component, but it should not be the only thing where you just pay your money and you get out. Bob.
Just so I understand, maybe you just answered this, the advocates on the other side that you alluded to, so money bail is just a bad thing, and inherently hurt people who can't afford it. supervision, some form of it is better, fairer, and more individually based. What about their contention that money bail is simply irrelevant or unfair?
Well, I would say, I'm not going to get into policy arguments that they might make. Certainly at the pre-arraignment stage, before a case has ever been looked at by a judge, money in and of itself, in our view, is, as the only means, is unconstitutional. What role money plays down the road in terms of a component after a judge reviews a case, we'll have to see. But right now, what we're dealing with is pre-arraignment bail and having money and wealth the only dictator. Yeah.
Is this something that San Francisco can do because it's a small place and it's a relatively wealthy place? A judge, you said a judge should adjudicate each case. Well, in a lot of systems, each person stands up and it takes, 15 seconds, a minute, 2 minutes, before their case moves along. It's just the caseload is so large. Is this something that is unrealistic?
I don't think so.
San Francisco?
No. I mean, Washington, D.C. does it. The federal system does it. And you know what? I got to say, I don't think convenience should be the dictator of what's just, and just convenience dictates what sort of justice people that are charged with a crime get. It's something that we're all entitled to equal protection under the law. It doesn't say we're all entitled to equal protection under the law only if it's convenient.
Or based on how much money you have.
Or how much money we have. That's right. Bob.
So, you're withdrawing your defense, and I haven't seen a filing yet, but you're going to affirmatively file it was unconstitutional?
We filed affirmatively today that we will not be defending the case, and I am saying that it's unconstitutional.
You're saying it's unconstitutional, but it's up to the plaintiff to make that case, you're not helping them.
Correct. Okay.
Thank you very much.
Thanks very much.